Hi everyone, I'm Lisa Burton Crawford, and this lecture provides you with an overview of principle of legality, which is one of our most important and contentious principles of statutory construction. So what is the principle of legality? The principle of legality is a presumption of statutory interpretation. It means that courts will presume legislation is not intended to abrogate fundamental common law rights and freedoms unless the statute says so clearly. So in other words, if a statute is open to more than one possible interpretation, the court will choose the interpretation that leaves fundamental common law rights and freedoms intact. The example of the principle of legality in practice that you have in your readings for this topic is Coco and the Queen. And this case gives us a really clear insight into how the principle of legality works, the type of rights it protects, and the strength of the presumption, or in other words, the degree of clarity that is required in order to rebut this presumption. So I've extracted and summarised the key provisions of the statute that was in question in Coco and the Queen here for you. And you can see that the main issue for the court was whether the actions of the Australian Federal Police fell within this exception in section 43(2)(c), and whether they were permitted to do what they had done in this case, or whether they fell within the general criminal prohibition against using a listening device to record or listen to a private conversation. So the facts of this case are very interesting. We have Australian Federal Police officers who want to use a listening device to record and listen in to the conversations of an individual who they think has been engaging in criminal activity. Now, what the police officers do in this case is they effectively trick the individual into letting them on to his premises. They pretend to be Telstra workers, or I think at that point in time still it was called telecom workers, and pretend that they want to enter his property to perform services as telecom workers. But what they are really doing is surreptitiously installing a listening device so that they can record his private conversations. So very, very sneaky. And you can see that the interpretive questions in this case really focus in around the meaning of the term use. So the statute quite clearly provides that it is not an offence to use a listening device where the user is a member of the police force, as the officers were here, acting in the performance of his duty and authorised in writing, that is, they have a warrant. But you can see that there are at least two possible interpretations of section 43(2)(c). On the one hand, we could take what we might call a pragmatic or purposive reading of that section, and we could say, in order to use a listening device, you have to install it. You can't use a listening device that hasn't been installed. So we should read this provision broadly as if it implicitly permitted the AFP to also install the listening device. It doesn't say that expressly. There aren't words in this statutory provision saying that police officers can also install the listening device, but you can see it would potentially frustrate the operation of this statute if it didn't extend to authorising the installation of the listening device. But on the other hand, let's think about what the police officers did in this case and the consequences of that. they tricked a member of the public into letting them in to his private property. So he didn't give effective consent to allow them onto his property because he thought they were telecom workers. He didn't know that they were AFP workers there to record his private conversations. And so if they were not specifically authorised to do that under this legislation, then the AFP had committed what would be recognised in law as a trespass. They invaded this person's private property without permission and without legal authority. And that fundamental right against trespass is a very, very long-standing rule of the common law, and it's regarded as one of great importance. It is a means of protecting the sanctity of the home. It is a means of protecting private property. And it is a means of ensuring that members of the police and other government actors can't just barge into your private home or business whenever they choose to. Your home is private and it is unlawful to enter it without your permission or without legal authority. So the High Court, in interpreting this provision, was confronted with an interpretive choice. Do we interpret the provision broadly and assume that it also permits what would ordinarily be a trespass so that the AFP can install and thereby use the listening device? Or do we read it narrowly and say, well, it does not expressly authorise what would otherwise amount to a trespass, and therefore we conclude that it does not? And in accordance with the principle of legality, the High Court chooses the narrow interpretation. They say we have here clear and unambiguous authorisation of the use of a listening device, but not the installation of a listening device in circumstances where that would otherwise be a trespass. So in other words, Parliament has not clearly abrogated that fundamental common law rule, and therefore, in accordance with the principle of legality, we conclude that that is not what the statute means. So in this case, the actions of the AFP did not fall within that exception and they were unlawful. So why do we interpret legislation in this way? What is the justification for the principle of legality? The traditional justification for the rule is what I would call an intentionalist justification. And what that means is, first, that it's the court's job to interpret legislation in a way that gives effect to the intentions of the enacting Parliament. And secondly, that it is unlikely that Parliament intends to abrogate fundamental common law rights and freedoms. And we see that assertion made in the case of Potter and Minahan. Now, that justification has fallen into disfavour. People really question whether that's a persuasive claim. People doubt that Parliament doesn't intend to abrogate the common law. People suspect that Parliament routinely intends to abrogate the common law. Now, that is in part because we have legislation that does abrogate quite fundamental common law rights and freedoms in a way that some people regard as very unfortunate. But it also has a more benign quality, which is that this is what contemporary parliaments do. There is almost no area of the law that remains untouched by legislation. There are very few areas of the law that now consist solely of judge-made rules. So in every area, we see Parliament changing the common law. So it just seems improbable to claim that they don't intend to do so. If anything, it seems unlikely that Parliament doesn't intend to abrogate fundamental common law principles. That then caused the principle of legality to be justified in a different way which I would call a democracy enhancing justification. And you see a statement of that kind that I've extracted there for you from Coco and the Queen. How is it that the principle of legality could enhance the democratic process? The claim is that it does so in two ways. The first is that it just ensures that rights are not abrogated by mistake. Contemporary legislatures consider a huge volume of proposed legislation, enact a huge number of statutes every year, and it is possible that Parliament sometimes fails to appreciate the full consequences of every statute they enact. So we would not want to see fundamental common law rights and freedoms abrogated inadvertently. The second way in which the principle of legality enhances the democratic process is that by demanding clear words, the principle of legality ensures that Parliament really turn its mind to the question of whether it wants to abrogate a fundamental common law right or freedom, and really deliberates upon that question properly. So it enhances the democratic process, not in the sense that it removes Parliament's ability to abrogate the common law, because that is quite within the scope of its constitutional powers, but in the sense that it discourages Parliament from doing so without proper scrutiny, proper debate, proper deliberation on whether this is the right choice of legislative action. And you will also see it sometimes claimed that this enhances the democratic process in a broader sense, which is that by insisting on clear words, the effect of legislation is also very clear for us members of the public to see. So we can see the rights restricting consequences of the law on its face, and we can take that into account in making our electoral choices. So that second democracy enhancing justification now tends to be the preferred way in which the principle of legality is explained. Now, I flagged for you at the start that the principle of legality is a contentious principle. By that, I mean that there remain a lot of questions about how it operates, and there remain controversies surrounding its use. So the first question is, which rights does the principle of legality protect? Coco and the Queen gives us a really clear example. There are rights and freedoms that are recognised and protected by long-standing common law doctrine, particularly the torts. So the tort of trespass protects the privacy of the home. The tort of false imprisonment ensures that you cannot be deprived of your liberty except by detention which is authorised by law. So if you had, for example, legislation that could be read as authorising detention, but also could be read as not authorising detention, the court would prefer the rights compatible interpretation if it could. So the first and most clear category of rights protected by the principle of legality are those common law rights recognised in long-standing doctrine. But it seems quite clear that the principle of legality extends beyond this. So, for example, the principle of legality is said to protect the freedom of expression. Now, this is not so clearly recognised by the doctrines of the common law, but it is clearly reflected and protected in limited ways by common law doctrine. So freedom of expression, regarded as a fundamental expression, that engages the principle of legality. Another example are the rights, privileges, immunities that have developed over time to safeguard the interests of the accused in a criminal trial. I'm talking here about things like the right to silence, the privilege against self-incrimination, protection against double jeopardy, which is the idea that a person can't be prosecuted twice for the same crime. Now, a lot of those protections have now been enshrined in legislation, and a lot of those protections have been curtailed by legislation, but they are another kind of fundamental freedom which the principle of legality is understood to protect. Beyond that, there is debate. So, for example, some people have questioned whether the principle of legality should protect the full catalogue of human rights recognised by international human rights law. The Australian case law does not seem to support that view, but that's a question that is still discussed. The second question I've posed for you there is flagging you to, alerting you to a broader controversy about the principle of legality, which is it a yes/no question? What do I mean by that? I gave you an example before of legislation that could be read as either authorising detention or not authorising detention. So that's a yes/no question. And the principle of legality would presume that Parliament doesn't intend to deprive a person of their liberty unless it says so very clearly. But what about a situation where we have a statute that clearly authorises detention? So clearly deprives a person of their liberty, but is ambiguous as to the extent of that deprivation. So, for example, is ambiguous as to the duration of detention that has been permitted. Does the principle of legality permit the courts to read legislation narrowly so as to reach the least rights restrictive meaning? That's a question, the answer to which judges have disagreed on. And the third question is, how clear do the words have to be to rebut this presumption and abrogate the common law right or freedom? In a nutshell, I would say that the words have to be very clear. And you see here this quote from Coco and the Queen that really sums up the orthodox position, which is we require a clear expression of an unmistakable and unambiguous intention. So as Justice Kiefel said in the case of Lee and Crime Commission, that is not a low standard. It is not a low bar. We are looking typically for express words, so you can actually point to something in the statute that abrogates the common law and leaves no room for doubt, makes it very, very clear that yes, Parliament wanted to limit the common law right or freedom in this circumstance. Now, for the sake of completeness, I want to alert you to the fact that not everyone is comfortable with the robust way in which the principle of legality is sometimes applied. There are some judges in recent cases who have started questioning whether the principle of legality has been applied too strongly and whether we have seen cases in which Parliament has actually made it quite clear that it intends to abrogate the common law, but the courts have concluded that it was still not clear enough. And you can see that that debate really reflects the constitutional boundaries of statutory interpretation and judges disagreeing about when that boundary has been reached. Because as we know, it's a fundamental rule that courts have to ascertain the meaning of a statute, but they cannot rewrite it. So The orthodox position is that the words have to be very clear, but again, that is a topic of debate. And I think that orthodox position is really well captured by this quote, which I will leave you with, which is from the judgment in Momcilovic and Queen, and the Queen also in your readings for this topic. And it's a quote from Chief Justice French, and he says, "Statutory language may leave open only an interpretation or interpretations which infringe one or more rights or freedoms. The principle of legality is of no avail against such language." So I think that this sums up for us really the rights protecting capabilities of the principle of legality, but also its limitations. So you might have seen in the works of Dan Maher and other academic commentators that are referred to in the readings that the principle of legality is sometimes seen as an interpretive tool for protecting rights in the absence of a Bill of Rights. And undoubtedly, it serves a purpose of that kind. But like all interpretive principles, it must operate within the confines of statutory interpretation and within the confines of judicial power. And as I've mentioned, the most fundamental of these is that courts cannot rewrite legislation that it was within the constitutional power of the Parliament to enact. So if we return to our democracy enhancing justification for the principle of legality, it seems that the courts have said they can generate interpretive rules that encourage or force Parliament to really think about when it wants to abrogate the common law and really be explicit about those choices and pay the political cost, whatever that might be, for doing so. But in the absence of a constitutional Bill of Rights, it remains within Parliament's power to abrogate any common law right or freedom if it chooses to do so, no matter how fundamental we might consider it to be. So in cases like Coco and the Queen, where a court is confronted with an interpretive choice, it is legitimate for it to choose the reading that is consistent with fundamental common law rights and freedoms. But as Chief Justice French says here, if the statute is unambiguous, if it does not permit a choice to be made, then the principle of legality has no more work to do. I hope that those principles are clear and have helped you to understand the principle of legality.